Hi everyone, thanks so much for joining us today in our webinar. My name is Jennifer Singh Jenkins and I'm a labor and employment lawyer here at McInnes Cooper's Halifax office. And I'm joined today by my colleague Ryan McCarville, who also practices labor and employment law out of our Charlottetown office. So we are here today to chat about a new development in workers' compensation law in Nova Scotia, though it does have broader applicability across the Atlantic region and outside of that as well. And so getting started here, get my screen going. So the legislative change we're going to be talking about is the introduction of gradual onset stress in the workers' compensation regime in Nova Scotia. And I think it goes without saying that there's many reasons that employees experience work-related stress, whether it's work-life balance, interpersonal issues with their coworkers, heavy workloads, whatever the issue may be, people do experience stress in the workplace and because of work. And obviously, stress is something that employers are currently trying to address and want to address, but it's really coming even more to the forefront now that gradual onset stress is something that can actually be a compensable injury under workers' compensation legislation in Nova Scotia. And so when we think about workers' compensation, typically, what I immediately think of are, of course, physical injuries, and in some circumstances, traumatic mental injuries like post-traumatic stress disorder. But recently, many provinces across Canada have changed their workers' compensation legislation to include gradual onset stress, and you can see that there's 6 here who have done so, and Nova Scotia is the 7th and the only Atlantic province to have done so far. Federal employers also cover gradual onset stress through their workers' compensation regime. And so this change to include gradual onset stress really aligns with societal changes where mental health is included in the overall picture of health, not just physical health. So there's really been a shift in societal thinkings and attitudes toward what health actually is, and that's now being reflected in the legislation. And so again, it's not necessarily gradual onset stress being a compensable head under workers' compensation law is not something that's necessarily new, but it is new to Nova Scotia and the Atlantic region. So these new changes came into effect September 1st, 2024. So we're 26 days into it now. And I'm going to talk about those changes, but I just want to talk briefly about what the overall workers' compensation regime looked like pre-September 1st, 2024, and what kind of coverage mental health injuries previously received under workers' compensation legislation. So pre-September 1st, workers' compensation, of course, covered physical injuries, and mental health had some limited coverage. So when we look at the definition of accident here, a workplace accident did not include stress unless it was from an acute reaction to a traumatic event. So that particular injury, acute reaction to a traumatic event, was what was previously covered pre-September 1st. And so an example of this would be a worker perhaps witnessing a fatality in the workplace and then suffering from post-traumatic stress disorder as a result. So previously there was coverage for stress, but again, it had to be an acute or traumatic event that it came from. As well, a component of proving a stress-related accident claim was that a worker had to have actually been diagnosed with a recognized condition in the DSM to qualify. So there was that kind of diagnostic threshold as well. It couldn't simply be a physician's note saying, I feel stressed as a result of this event. And so I'm just going to briefly touch on a case that occurred before the new gradual onset stress changes came into effect in Nova Scotia, because it shows how these changes and the inclusion of gradual onset stress have really been a long time in the making and have been something that have been talked about for quite a while. So this case that I'm going to reference is from 2012 and was appealed to the Nova Scotia Workers' Compensation Appeals Tribunal in 2014. So it's a 10-year-old case. But what happened in that case is that a worker faced threatening behavior from their coworker, which actually resulted in the worker developing post-traumatic stress disorder in 2009. And so a WCB found that the workers' PTSD was a compensable injury and provided them with earnings replacement benefits for a period of time. The worker then came back to the workplace, fully reintegrated. She was no longer sitting anywhere close to the worker who had engaged in the threatening behavior that caused her to suffer her injury. And she worked for almost a 3-year period successfully in the workplace. But then in 2012, she advised the Workers' Compensation Board that she was again experiencing post-traumatic stress disorder symptoms, which she said were related to that 2009 incident where the PTSD had originally arisen. And so the WCB denied the worker additional benefits, and the worker appealed this decision to the Workers' Compensation Appeals Tribunal. And so the WCAT determined that after December 2009, the worker was able to recover virtually completely and make a fully functional return to work. And while there is some medical comparability between that 2009 PTSD diagnosis and that 2012 PTS diagnosis, there lacked that link or that continuity between the 2009 and 2012 diagnosis in order to establish that it was a compensable injury. And so what the WCAT ended up concluding in that case was that intervening events, together with evidence of gradual onset depression and anxiety, suggest that the worker's condition may more appropriately be considered a new injury, albeit an injury which may fall within a statutorily excluded form of psychological illness under the Act. And then they go on to say, the evidence suggests that there were intervening events which led to the worker developing depression and anxiety, so essentially gradual onset stress, which is not compensable under the Workers' Compensation Act. And so I think this case is, even though it occurred prior to these new legislative changes, I think it's important because it highlights that gradual onset stress has been a topic of discussion and a long time coming in Nova Scotia. And gradual onset stress as an injury is by no means a new injury or a new class of injuries. It's been around for a while, as this case kind of shows. And really, now that we see it included within the legislation, it again goes to that kind of change in that societal change in thinking about what actually comprises health, and really goes to show that mental health incidents in the workplace can have just as much of a consequence, if not more, on a worker's ability to work than physical injury. Okay, so getting into what the changes actually are under the new workers' compensation amendments in Nova Scotia. This on the slide is the bulk of the amendments that have been made. So for such a large change, the actual legislative amendments are very sparse and very small. So here is what is need to be shown for a gradual onset stress claim. So a worker is entitled to compensation for gradual onset or traumatic mental stress if the stress both arises out of and in the course of employment. So that's kind of point number one, and is wholly or predominantly caused by one or more significant work-related stressors, or a cumulative series of significant work-related stressors. So that's kind of point number 2. So gradual onset stress, again, covers work-related psychological injuries that take place due to significant stressors. And I want to emphasize that point about significant stressors, because it's not every stressful event in the workplace that is going to be covered. And Ryan will kind of get a little bit more into that later on in the presentation when he discusses some of the exclusions. But some of the stressors that would be covered or would fall under this legislation are workplace harassment or bullying in the workplace that builds up over time. And so I'll kind of briefly go over a policy that the Workers' Compensation Board recently released, because as I mentioned, those legislative amendments that actually introduced gradual onset stress as a new head of compensation under workers' compensation are very sparse. So recently what the Workers' Compensation Board did here in Nova Scotia was they released an interpretation policy, and that came into effect September 1st, 2024. And while that's not this, it doesn't have the same effect as a piece of legislation, it is a good indication of how the Workers' Compensation Board is going to approach interpreting some of these new terms that come up in gradual onset stress claims. And you can access that policy on the WCB's website. So I recommend taking a look at that. And they also have a number of good webinars that kind of further explain gradual onset stress claims. So under this policy, in order for an employee to prove to the Workers' Compensation Board that they have a claim for gradual onset stress, they need to prove, 1, that the injury arose out of and in the course of employment, 2, that they actually have an injury, which the policy defines as a DSM diagnosis. So similar to an acute traumatic incident and stress arising from that, there has to be that actual diagnosis. A worker can't just say, hey, I'm stressed. Number 3, their injury is due to one or more significant work-related stressors. And number 4, the WCB decision maker is able to identify the events which are claimed to have caused the mental stress, meaning that the events are the clear cause of the mental stress. So I'm just going to briefly discuss some of the policy definitions and of gradual onset stress, mental stress, and significant work-related stressors. So those terms that we see in the legislative amendment and what they mean according to the policy. So starting with gradual onset stress, the policy defines this as mental stress that is a response to experiencing a single significant or course or series of non-traumatic events over time. And within this definition of gradual onset stress is mental stress. And so the policy goes on to further define mental stress as an individual's non-specific physical and psychological responses to the events or changes that occur in a person's life that result in a diagnosed psychological injury. And again, I think it's really notable that there has to be that diagnosed psychological injury. It can't just be an employee self-reporting that they are stressed. And it can't even be a diagnosis from a family physician. The policy is clear that there has to be a diagnosis from either a psychiatrist or a clinical psychologist. So under the policy, it says that only those 2 individuals can make that DSM diagnosis that would potentially be covered under workers' compensation. So I'm sure a lot of us see physician's notes coming across our desks that say someone has anxiety or is being diagnosed with anxiety. That is not going to be sufficient in order to enable them to make a claim under this new gradual onset stress regime. And again, I want to go back to the point that stress is only compensable if it arises out of a significant work-related stressor, and that is also defined in the policy. And so it includes examples of harassment, bullying, and traumatic events. And the stressor must be significant in intensity compared to normal workplace pressures. Um, and so what WCB says in the policies is that they may consider other stressors to be significant where they've lasted for an extended period of time, arise from incidents or actions that are serious and egregious in nature, and are overall just beyond the normal pressures and tensions of employment. And so in determining whether a significant work-related stressor is that, what the WCB will consider is the worker's subjective response to the stressor, but they'll also consider would a reasonable person have a similar response to the stressor as the worker did. So it's a dual test. It's a subjective, objective test that is used to determine whether or not a stressor is in fact a significant work-related stressor. So I just wanted to go through these definitions because I think they're important to keep in mind when thinking about these types of claims. And I'm going to turn it over to my colleague Ryan now, who is going to be chatting more about what are some of the exclusions under the new gradual onset stress regime.
Thanks, Jennifer. And thank you all for joining us here this morning. As Jennifer said at the start of the presentation, I practice in PEI, so this legislation does not apply to many of my clients yet, but certainly I'm watching it closely because whenever this type of change is made in one jurisdiction, there does tend to be a domino effect across other jurisdictions as well. So I think it's only a matter of time before this change is made to the PEI legislation and the rest of Atlantic Canada. Um, Jennifer also mentioned the WCB policy, and uh, I want to put a bit of a plug in for that. The WCB website in Nova Scotia and that policy has some really useful information. So if you're dealing with a claim under workers' compensation for gradual onset stress, I strongly recommend you have a look at their resources because they do have some very helpful resources in the event you face a claim, and also some advice on avoiding that type of claim going forward, which I'll also be discussing here today. And as Jennifer said, the WCB has come out in Nova Scotia has indicated in their materials that most often this change is going to apply to long-term exposure to psychological hazards, primarily bullying and harassment. So it seems like that is sort of the crux of why these changes were made, having to do with long-term bullying and harassment in the workplace and creating that as a compensable injury under workers' compensation. It can obviously include other circumstances as well, but that seems to be kind of perhaps the driving force around these changes. And whenever these types of changes get made to legislation, there's always a concern among lawyers and among our clients that this is going to create a floodgates of claims. But the legislation does include a number of exclusions, so it's not a low threshold. I mean, you hear the title stress, and everyone's stressed. I think we can all acknowledge that to a certain degree, but there is a threshold that needs to be met in order to prove a compensable claim for gradual onset stress under the legislation. And I'll just get you to go to the next slide, Jennifer, because I want to review some specific exclusions in the legislation to a compensable claim under the Workers' Compensation Act of Nova Scotia. So there's two broad exclusions. Excuse me. The first exclusion is a decision or action of the workers' employers relating to the workers' employment, including a decision to change the work to be performed or the worker's working conditions, disciplining the worker, or terminating the worker's employment. These exclusions have been included in the legislation to reflect the fact that management is entitled to manage the operations of the workplace, and to also recognize that when these types of things happen to an employee, they are stressful, but they're not the level of stress that gets created that should be compensable under workers' compensation legislation. So with that first bullet there on the right, a change to the work to be performed or the worker's working condition, changing an employee's hours of work, changing their workload, changing how the work is to be performed. If that results in stress to the employee, that is not going to be compensable uh, under the legislation. Disciplining the worker as well. The legislation recognizes that getting disciplined can be a stressful experience. I'm sure it's stressful for you in HR as well, but it's also stressful for the employee. But that's not a compensable injury. And same with termination of the individual's employment. Yes, that may be stressful, but it's not stressful in the sense that it's compensable under the legislation. There is a second exclusion as well, Jennifer, and I'll just get you to go to the next slide there. So the second exclusion to compensation under the legislation is interpersonal conflict arising out of or in the course of employment unless it constitutes workplace harassment or bullying. So interpersonal conflict does not entitle someone to compensation under this new amendment unless it reaches that threshold of harassment or bullying. Now, interestingly, the amendments actually do not define bullying or harassment. But there is kind of in the case law and in legislation across the country, there is sort of a generally accepted definition of harassment, which we expect to be applied in adjudicating these types of claims. And I'll read the PEI Occupational Health and Safety Act workplace harassment regulations. I'll read that definition, which is the generally accepted definition in the case law. It says harassment means any inappropriate conduct, comment, display, action, or gesture, or any bullying that the person responsible for the conduct, comment, display, action, or gesture, or the knows or ought reasonably to know could have a harmful effect on a worker's psychological or physical health or safety. So as you can see, it's a very, very broad definition because it needs to capture a wide range of actions that could lead to a harmful effect on the worker. We've included on the screen there generally what that definition may include, or what may be included as harassment or bullying. And you'll see in the last bullet point there, it's not going to include reasonable management actions respecting the direction of the workplace or the operations of the workplace. Those are generally excluded in harassment policies, and then also that would likely fall under the last exclusion that I reviewed on the last slide as well. So those are the exclusions that are set out in the legislation to a claim for gradual onset stress. And I want to turn now to investigations. So as I'm sure most of you on the line are aware, harassment complaints have really taken off in the last, I'd say, 5 to 7 years. We've seen a huge increase in the number of complaints being filed under harassment policies, and the timing of it it appears maybe aligned with the Me Too movement, and then also some of the legislative changes that we've seen provinces make with respect to their occupational health and safety legislation around requiring workplace harassment policies. So employees are really becoming aware of their rights to file a harassment complaint with respect to conduct that they view as inappropriate. And often when an employee files a harassment complaint, in the workplace, there's other complaints or claims that accompany that. There may be a grievance under the collective agreement or the no harassment provision of the collective agreement at the same time as the complaint in a unionized environment. There may also be a human rights complaint if the conduct is based on a discriminatory ground that you're having to deal with, as well as dealing with the harassment complaint. And then finally, there's also in the non-unionized setting a potential for a constructive dismissal claim for a poisoned work environment that you may be dealing with as well, in addition to a harassment complaint. And now add on top of those potential claims and complaints a, um, a complaint or claim for compensation under the Workers' Compensation Act. Or workers' compensation legislation in Nova Scotia, which is obviously going to take more of your time and potential cost as well in dealing with that side of things. Now, these amendments, though, do not change your obligation as an employer when it comes to preventing harassment in the workplace, as well as investigating harassment complaints in the workplace as well. Um, if you get a harassment complaint in the workplace, obviously you'll do your investigation, you'll meet with witnesses, gather evidence, and make certain findings. This legislation doesn't change any of that. That investigation should still take place, obviously. The complicating factor in it is that WCB is going to do their own investigation, which is going to be a separate process. And we're still sort of trying to figure out, in some ways, what that investigation may look like. And so I reviewed the WCB policy that Jennifer referred to earlier to see what it had to say about what a WCB investigation into gradual onset stress would entail. And obviously, they've kept their comments on their investigation fairly broad, given that these investigations can go in a number of different directions. But I just want to read for you what their policy says. It says, the work-related stressors that lead a worker to file a claim for compensation for work-related psychological injury must be reasonably confirmed through information verifying that the work-related stressors have occurred. This will be done by gathering and considering information from a variety of sources, including but not limited to interviews and or statements from the worker, co-workers, healthcare professionals, the worker's supervisory staff, the employer, and members of the public. Many workplaces have internal processes for investigating harassment or bullying allegations. The WCB will review all information submitted by workers and employers, including investigation findings, and consider all evidence identified during the decision-making process. So they've sort of indicated what their investigation may look like. It does indicate that they're going to review all information, including investigation findings. So that's why it's, again, important for the employer to do their investigation into the allegations, and then you have that information for the purposes of the WCB investigation as well. I'll go to the next slide there, Jennifer. Thank you. These are sort of to-dos with respect to workplace investigations. I'm sure you're all probably aware of these to-dos and what an investigation should look like. The legislation that we have in PEI is very broad in terms of an employer's obligation to investigate. It requires the employer to do an investigation that's appropriate in the circumstances. So Section 6 of the Workplace Harassment Regulations here says that the employer shall ensure that an investigation appropriate to the circumstances is conducted into a complaint of harassment in the workplace. So obviously the investigation is going to depend on, that you do as the employer, is going to depend on what the allegations are, who's involved, and the circumstances surrounding the allegations. It is important that the investigation be timely for a few reasons. One, memories tend to fade over time, and so the best evidence you're going to get is uh, the evidence that you gather shortly after the alleged incident. If you wait to do the investigation, the evidence may get tainted or lost over time. But the second reason is that, as WCB has come out and said in their policy, they are going to look at, or um, they may look at your investigation findings as well. So if you can complete your investigation in a timely manner, you will have that information during the course of the WCB investigation into the claim as well. Um, the investigation should also be thorough and neutral and fair. Your role, or the employer's role, is to not to prove a case, or set out on a path to prove a case. It's to determine the facts and gather evidence, and it should be neutral throughout the course of that investigation. Obviously, it's important to document the various steps to the investigation as well, and gather any relevant documents that you may have. And then finally, at the conclusion of the investigation, you make findings and a decision um, regarding the evidence that has been gathered. We could do an entire morning presentation on what a proper workplace investigation looks like. We don't certainly intend to do that, but I did want to kind of highlight the key points of a proper workplace investigation. So with that, Jennifer, I'll go to the next slide. Besides conducting investigations into complaints, it's also important to address issues as they arise in the workplace before hopefully they uh, reach the level of a formal harassment complaint or a claim to the Workers' Compensation Board. And it's also important to create a psychologically safe workplace. And as I said, the WCB website has some really great resources for employers on creating psychologically safe workplaces, makes a number of recommendations, including workplace workload management, engagement of staff, clear leadership, clear expectations for staff, providing recognition and rewards. So I encourage you to look at that as well. Um, it's interesting in Nova Scotia. So the Nova Scotia Occupational Health and Safety Act, as most um, acts or legislation across Canada, has a very broad obligation on employers to take every precaution, or every reasonable precaution in the circumstances, to ensure the health and safety of persons at or near the workplace. The violence in the workplace regulations, the focus of those are on physical safety. So it's interesting that um, those regulations focus on the physical side of things, or physical safety, not psychological safety. But the act itself contains that very um, broad obligation on employers. And even more interestingly is that there are some upcoming amendments that are going to be made to the Occupational Health and Safety Act. If you could go to the next slide, Jennifer. So there's been a bill recently introduced called the Stronger Workplaces for Nova Scotia Act, and I'm always interested as to how these acts get their names. But in any event, this act does a number of different things to change some legislation that applies to workers in Nova Scotia. But one of the things that it does is that definition we looked at earlier, that obligation on employers that we looked at earlier, to take every precaution that is reasonable in the circumstances to ensure the health and safety of persons at or near the workplace. It amends that obligation to add a definition of health and safety to include both physical and psychological health and safety. So that obligation has been read into, or we've read into that general obligation for a while now. That wasn't necessarily limited to physical health and safety, but it could include psychological. But now it is specifically going to be in the legislation to make that an obligation on employers. The other thing that the other important thing that this legislation does, or this bill does, is that it's going to create in Nova Scotia um, a requirement for employers to establish and implement workplace harassment prevention policies. Now, I was surprised that uh, I, I learned this a few years ago, but I was surprised that Nova Scotia did not have any obligations in their occupational health and safety legislation requiring employers to have harassment policies, because that's a requirement in most, if not all, other jurisdictions. In PEI, I believe it was in 2020, we made a change to our Occupational Health and Safety Act here to make that a requirement for all employers to have and a harassment policy, which sets out kind of the complaint process and the procedure to investigate and what a policy has to include. And now that change has been made in Nova Scotia. So those changes come into effect September 1st of next year, of 2025. Um, the details on what that looks like will be provided at a later date, but certainly we know that it's coming. So certainly if you're an employer in Nova Scotia and you don't have a harassment policy because it hasn't been required, it's certainly time to start to implement one or start to think about implementing one. I'll go to the next slide. Thank you. We did just want to highlight that in addition to a claim under workers' compensation, there's also failing to prevent or address harassment in the workplace can lead to a number of other complaints or claims, which I've already talked about a little bit, which can add expense and administrative time to address. Failing to create a psychologically safe workplace can lead to a grievance if you're in a unionized setting under the collective agreement. Most collective agreements have provisions around harassment in the workplace. And so a grievance could be filed under that article of the collective agreement. If you have a workplace policy, a complaint can be made under that. And the legislation in most provinces requires an investigation into those complaints. There can also be a complaint under human rights legislation. The Supreme Court of Canada has said for more than 30 years now that sexual harassment is a form of sex discrimination under human rights legislation. There could be in addition to that, there could be an employment standards complaint as well. So in PEI, for example, there's provisions in our employment standards legislation regarding sexual harassment and the obligation on an employer to make staff aware of its policy and to have a policy in place. And then lastly, there could be a civil lawsuit for constructive dismissal. So an employee claims that the workplace is so toxic that they were left with basically no choice other than to quit their employment, and so they've effectively been terminated because they were forced to resign from their employment, which obviously can be can take time and money to dispute, to engage in that dispute. So certainly things as employers we want to avoid, which is why it is important to take complaints seriously and do what you can to prevent harassment complaints in the workplace and to create that psychologically safe workplace. So as I've said, I think most employers now have, whether you're required or not in Nova Scotia, have harassment policy in place. Certainly in other jurisdictions, it is a requirement. If you don't, in Nova Scotia or any other province really, certainly we strongly recommend having that policy in place and ensuring that it complies with the requirements of the legislation. The the policy should outline the complaint process and how a complaint gets submitted and the information that should be included in a complaint. And in addition to that, I always encourage clients to uh, have in their harassment policy an informal resolution process and to really encourage the informal resolution process, whether it's mediation or encouraging the individual to bring up their concerns if they're comfortable doing so with the respondent, because going through a formal harassment complaint process is really not fun for anyone. It's not fun for the respondent to get accused of harassment, but it's also not fun for the complainant to have to go through that process, meet with possibly an external investigator, get questioned on what happened. The respondent's going to become aware that they've made the complaint, which may create an uncomfortable work environment. And oftentimes the complainant just wants the behavior to stop, and so they've taken the approach of filing the formal complaint, but maybe haven't thought through exactly what that could do to the relationship with the respondent. And so in your harassment policy, it should have provisions around the complaint process, but as I said, also encourage informal resolution where possible. It should also, as employers, we should be providing ongoing training to managers in particular, but also staff on the policy and the obligations under the policy. And in PEI, for example, under employment standards legislation, it actually says that you have to make the employees aware of the policy. So it's important that not only when they get onboarded are you reviewing that policy with them and getting them to sign off on it, but also as an ongoing measure, reviewing that policy with them and going over what their obligations are. So with that, I don't know if you have anything to add from what I've said, Jennifer.
Yeah, no, thanks. Thanks. That's great, Ryan. And I do see that we have a couple of questions in our chat here. If anyone has questions, please feel free to type them in, and we'll try to get to those. So our first question is, can employers mitigate the issue / damages in any way, such as demonstrating an investigation was carried out when a claim of harassment is made? And part two, does the employee have a duty to mitigate, such as to bring the issue to the employer's attention, or can the employee stay silent on the issue and then bring a claim to WCB? So in terms of, I think that's an excellent question, because as lawyers, our whole thing is about risk mitigation and how can we assist you as clients and employers and HR professionals in mitigating the risk in your workplace. So in terms of how we mitigate that risk, Ryan discussed a few ways that could be done. And it's not necessarily changing a lot of your current or existing practices to address the risk, but it's just making sure that you are staying on top of them. So as Ryan mentioned, conducting workplace investigations once a complaint comes to your knowledge, making sure that you're doing that promptly, having those harassment and bullying policies in place in the workplace and plans for preventing those, as well as keeping that psychologically safe workplace at the forefront of your mind at all times, and how you and as employer can contribute to the creation of a psychologically safe workplace. So really not necessarily changing what you're doing, but just doing more of what you're already doing, or just staying on top of what you're already doing. And
Yeah,
that'll yeah. Sorry, go ahead, Ryan.
no, I think that's a great question. Like under the legislation, there's no obligation on the employee to first file a harassment complaint with the employer, and that if that doesn't go their way, they then bring a claim under WCB. They are two separate processes, and theoretically, as I read the legislation, um, they can file a claim for WCB under WCB without filing a formal harassment complaint with the employer. I mean, oftentimes, I don't. I question how often that would happen. It certainly could happen, but generally, in my experience, employers are at least aware of something happening at the point that a grievance is filed or a human rights complaint is filed, or in this case, a workers' compensation claim is filed. They're aware that kind of something happened in the workplace. But theoretically, could the employer have no knowledge of it and then the individual go and file a WCB claim? Yes, same as they are permitted to file a human rights complaint. I do question what, um, I think when WCB does their investigation, I assume that those are going to be questions that they've asked, like, was your employer aware of this? To what extent was your employer aware of this? Did you file a harassment complaint under the harassment policy? So I expect that those are going to be part of the WCB investigation, and that may change whether the claim is compensable or not. There's certainly some unanswered questions though, and we'll have to work through these things as claims arise.
Yeah, I think you may have touched on one of our additional questions there, Ryan, but I'll just read it in case there's anything else that you might want to add. What is your suggestion on workplace investigations if the employee goes directly to WCB and doesn't inform the employer of the incident?
Yeah, I mean, I think that my general advice would be that it would be prudent for the employer to, if they became aware of the claim to WCB and became aware of the facts around what the employee is alleging, my general advice would be that it'd be prudent to do our own investigation as well as the employer, just to satisfy ourselves that the issue has been dealt with, and to also kind of get ahead of where WCB may be going with their findings. Um, yeah, I guess those would be my initial thoughts, is to kind of, we'd want to figure out kind of what happened and why it happened and who's involved and all that, if there was a claim. Same as if there was a human rights complaint filed. I mean, I would want to know kind of, okay, what are they alleging? Why are they alleging it? Do we have to, should we launch an investigation here? Or is this, do we believe this is completely without merit? In which case, we'll still do our homework, we'll gather our information, but maybe we don't need to go to the extent of doing a formal harassment investigation.
Yeah, and to Ryan's point, I think the again the benefit of doing your own investigation um, is that there are all these different avenues that someone with a harassment complaint can go through, whether it's human rights or constructive dismissal. So even if we even if the employee goes directly to WCB first, it's also prudent to do your investigation to ensure that you're mitigating the risk of the human rights complaint avenue or potentially a grievance or constructive dismissal as well. Not seeing any other questions. Um, so perhaps with that, maybe we'll end it there. But if you folks think of any questions afterwards, please do feel free to reach out to Ryan and I directly by email. And we'd love to hear from you. and we'll try to get back to you fairly quickly. Great.
Okay.
Okay. Well, thanks again, everyone, for joining us today. We really appreciate it.
Thanks.